Your medical malpractice case is coming up for trial, and now the defense asks us if we want to go ahead and mediate. If we go ahead and try and mediate, which is basically a settlement discussion, a private settlement discussion, am I worried that I'm going to be giving away my best strategies that I'll be using at trial? And more importantly, if we go ahead and mediate and we cannot settle the case, am I worried that what I say can be used against us at the time of trial? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, so here's the scenario. You believe that you were injured by a careless doctor causing you significant harm and injury. And now your doctor turned around and said, hey, wait a second, I did nothing wrong. And why are you suing me? And if I did something wrong, guess what? Whatever I did didn't cause you harm and injury. And if it did, by the way, your injuries really are not as bad as you claim them to be. Those are the typical defenses. Plus, they also say, hey, by the way, you, the patient, caused and contributed to your own injuries. So that's what we usually see as common defenses in these cases when a patient brings a lawsuit against their doctor. All right, so now at the very beginning of your case, the defense attorney tells me, hey, listen, there is no liability here. I don't know why you're bringing this case. We will never pay a dime on this case. Fine, so what does that mean? It means we're going to go the entire length of litigation, which could take anywhere from 2 to 3 years if your case is here in New York. All right, so that's exactly what happens. So now, as your case is coming up for trial, the defense calls me up and says, hey, listen, would you be interested in trying to mediate this case? Now, what is mediation? Mediation is nothing more than having a settlement discussion. But instead of having it with a judge who supervises your case in court, instead, we agree to go ahead and have a retired judge listen and try and facilitate a negotiation, or at least have settlement discussions. So now let's assume that we've agreed to mediate. What happens then is now each side has an opportunity to present our best arguments to the judge. Judge, I want to tell you right now, here's what happened in this case. The doctor in this case violated the basic standards of medical care, causing the patient the following injuries. And let me tell you why doctor number 2 is also responsible. And now we continue presenting our best set of facts to the judge. Likewise, when I'm done, the defense will have an opportunity to explain to the judge why they believe their doctors did absolutely nothing wrong, and they are not liable in this case. Once that happens, now the judge will begin to have private discussions, separate discussions with each attorney. And now he's going to try and find out from us whether or not we're really serious about trying to negotiate this case, whether or not each side can come to an agreement in order to try and settle this case before going to trial. Now, why is that sometimes helpful? It's helpful because when we go to trial, we have 6 members of the community who are going to sit in judgment to decide whether we are more likely right than wrong than what we are claiming is true. The inherent reality and the inherent problem with going to trial is we don't know what the outcome is going to be. Likewise, the defense doesn't know what the outcome is going to be. So even though we believe we have a great case, even though we believe we had great damages and that the jury will give us a verdict in our favor, the problem is we don't know that. We hope that's going to be the case, but likewise, the defense is going to be concerned that even though they believe they have a good defense and they believe that there's no valid case, it's still possible for the jury to come back in a verdict against them. So in an attempt to minimize and manage the risk on both sides, each side may be willing to agree to try and negotiate this case privately. So now we have a few hours of our time to go ahead and talk to a judge. So it's not in a high-pressure atmosphere where the judge in court has only a few minutes to give his time to talk to us to try and negotiate a case. So now let's get back to the question I raised in the title of this video, which is, if we are unable or unsuccessful in trying to settle this case during this private negotiation session, can the information that the defense learns from us now be used against us at the time of trial? The answer is yes and no. Here's what I mean. All right, when we go to trial, if we have settlement discussions and the case cannot be settled, the defense cannot turn to the jury during the course of trial or even opening arguments and say, ladies and gentlemen, Mr. Oginski and his client are being so damn greedy. They want $5 million to settle this case. We think this case is worth only $50,000. How dare they? He cannot talk about any settlement negotiations. He cannot talk about any discussion we had about the amount of money we were considering, or the amount of money that they offered, that is off limits. So now, under what circumstance can the defense use information that they learned during the course of negotiation? I'll tell you what they can learn. I'll tell you what they can use. They can use our strategies about how we're going to approach certain witnesses, about our focus of going after a particular expert, about a problem that one witness has about lying in the past. They can now use that information during the course of our settlement discussion to now try and prepare their witnesses for their anticipated cross-examination. And some of the key points I'm going to make because they learned this information during this private settlement discussion. So in that instance, yes, they can use that information to try and help their witnesses and try and fashion a strategy of how to address those questions and that questioning. And that's okay, because we do the same exact thing. Now I know exactly what the defense's strategy is. Now I can talk to my expert and focus on their strategy and find ways to get around it. So yes, we can use that information in an indirect way to help our witnesses and to go after their witnesses. But when it comes to actual amounts of money that we were talking about, amounts that have been offered, amounts that we are willing to accept, guess what? That is totally off limits. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what really happens in these medical malpractice cases here in New York. You know, I do understand that you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but have not done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day.